Obviously, as you all know, have a conversation today about design patents, where we are, and kind of where we see that going after, now that it's been about a year since Apple, Samsung. And something I'm really personally interested in, because I feel like when we're dealing with the law, there aren't that many moments where you can actually kind of craft something. You can take a step back and say, well, what's the purpose of this and how do we get there? And it feels like we're kind of in one of those moments when it comes to design patents. And there's this moment for this conversation that I hope we're going to have today, and hopefully you all will engage as well in that, to say, well, this is why we're doing this. This is how we best think we should get there. And, we'll see what happens with the courts. We'll see what happens in the Northern District of California. But I think that this is a really interesting and particular time. So we're excited about that. I'm going to go ahead and do some quick intros, at least of Matt and Charles. And then when Nagesh gets here, we'll let him maybe we'll just make him introduce themselves. So to my right, Matt Levy, former patent counsel at CCIA, where he handled legal, policy, advocacy, and regulatory matters related to patents, and wrote the amazing Patent Progress blog. He's here. No problem. Perfect timing. He made it. He's now a consultant on patent policy issues and patent litigation. Before joining CCIA, he handled patent litigation and patent prosecution in private practice. He also worked as a software designer for several years at IBM and is the co-inventor on a patent that is based on his work there.
Actually, 2 patents.
2. Oh, sorry.
That's okay.
2. To Matt's right, Charles Duan. He's Senior Fellow and Associate Director of Tech and Innovation Policy at the R Street Institute, where he focuses his research on intellectual property issues. Before joining R Street earlier this year, so new job, congrats, he was the Director of Patent Reform Project at Public Knowledge, where he handled all aspects of patent policy, ranging from outreach on the Hill to writing white papers and filing amicus briefs. Prior to this, he was a research associate to Professor Paul Ohm on an NSF-funded project that investigated the policy implications of newly proposed internet architectures. He also, too, works as a patent attorney at Novi Martins. And then finally, Nagesh Rao, who made it just in time. We're glad to have you. No problem at all. Is a 2016 USA Eisenhower Fellow and advisor to the AAS Lemelson Invention Ambassador Program. He has previously worked for the Rensselaer Polytechnic Institute's Office of Technology Commercialization, the National Academies, and the U.S. Department of Commerce's Patent and Trademark Office, which some of you might have heard of, as a patent examiner and later on as a senior policy advisor. Thank you guys all for being here. I should actually also quickly say I too was once upon a time a patent attorney many years ago, and I then worked at EFF where I focused on patent policy. So I had a great title, the Mark Cuban Chair to Eliminate Stupid Patents. It was a great title. It was Mark's idea, not mine. So with that, I'm going to, actually, I forgot, it's still my turn. I'm going to talk just a little bit more to kind of lay some background, set the scene just a bit for where we are. Obviously, Apple, Samsung, or Samsung, Apple, you guys are all familiar with the litigation. The jury verdict was originally awarded in the summer of 2012, so we've been at this a while, and obviously the trial before that. The jury awarded Apple just about $1 billion, 400 million of which fell under Section 289 special remedy provision. So we went to the Supreme Court, we went back to the Federal Circuit, now we're going back to the Northern District. It's one of these things, not quick. Though I will say, as someone who's been working on kind of patent policy for a long time, the case also has been incredibly interesting because it really changed the debate beyond just design patents, but more broadly. And I think part of the reason it did is because the patents are easy to understand to lay people, especially, the design patents in particular. You can really illustrate how a patent system works and what it's doing when you're talking about rounded corners as opposed to some really kind of intricate utility patent that might be incredibly hard for average people to understand. So it's long been something I've been following very closely for that reason and others. Here we are, still trying to kind of figure out what the test is. What is the article of manufacture test? What does that look like? Judge Koh has of course proposed this, or has said she's going to go with the Solicitor General's proposed test. I've got it here, but I'm not gonna read it all out loud because that would be long and boring. I think probably, if you're here, most of you are fairly familiar with what we're talking about, though we can dive in on that as we all get talking. Really quickly, too, I wanted to just address why Engine cares about this. Engine has been involved, has filed multiple amicus briefs on this particular case, but why it cares about the issue started. And Engine is really focused on working with really small startups. Tomorrow's Samsung, tomorrow's Apple. You know, I sometimes think of its interests in terms of the companies that don't even exist yet. What do we do to incentivize the kind of innovation and economic growth that allows companies to thrive, build more new cool things, and patent policy and design patent policy are so, I mean, obviously so closely aligned with that, which is why Engine cares, which is why I care, which is why we're here, and I hope that that's something we'll be able to talk about today as well. You know, what does this mean for people who are trying to build things, maybe who don't have a huge legal budget, maybe who have no legal budget, right, and are trying to figure this out. So I'm really incredibly interested in that. And so now, as we think kind of what's next, where we go from here, of course, is back to the Northern District. The lower court's gonna have to figure out how to identify the article manufacturer, how to attribute profits. You know, there's a lot of really meaty stuff. But a lot of questions remain around what is that gonna mean in practice? And again, what is it gonna mean for the innovators? What's it going to mean for the litigators? What's it going to mean for the system? And the innovators, little and big too, I should say. So that's kind of where we're at. I think that's the basic framework for the conversation. And I'm so glad that we've got these three guys here because they're truly experts in this. And I'm gonna let them each kind of kick it off by saying a few words and their thinking on this. And then we're gonna dive into questions. And I hope that we'll really have a conversation and we'll be saving time for questions. So write them down or think of them and we'll go from there. Thanks, so we'll just go down the road. Matt.
Well, thanks, Julie, and thanks so much for having me here. Thanks to Engine for inviting me. So I'm in the lucky position that I'm not representing anybody's point of view except for my own. So in this debate, what drives me nuts is sort of the trying to slam, you know, one part of the law into another part without really thinking through the consequences. And you know, I used to be a computer scientist before I got into the law. And there's just a lot of consequences that come when we try and take an area like design patent law and just apply it to computer science law, computer science, without thinking it through. And I think this case really illustrates what happens. So we see in this case, now two of the design patents are just about the physical characteristics of the phone, although they're pretty small physical characteristics, but we're still arguing about components. And then there's the screen layout of some icons on the screen. And I want to talk some about that. I don't want to take up everybody's time with the intro. But there's an important aspect here that I do want to talk about today. We'll get to that Apple is sort of trying to control the graphical user interface using a design patent, which I think is really problematic because design patents are not a good fit for that, I think. You know, design patents are intended for originally things like the rug. If you look down at the rug on the floor, the pattern on the rug, well, that's one of the intended uses of design patents. They've expanded to include other things, you know, and I think there are good reasons for that. And they certainly can be arguably included. I'm going to borrow your phone for a second.
Please.
You know, the shape of the phone, physical thing, but when you start to get to things that are depicted by the generation of electronic signals, I think it at least requires some thought before we do that, instead of just assuming that, yeah, sure, that's fine. And you know, when we see the consequences here, all of a sudden there's you know, $500 million in damages being assessed because of this, and we haven't really put any thought into whether that's the right fit. We also have copyright law, which covers look and feel of user interfaces, which Apple could have used but chose not to. We have utility patents, which cover graphical user interfaces, and Apple certainly has a bunch of GUI patents. So, you know, there's some real problems with using design patents in this way, and that's something that we definitely need to think about. So I'm hoping we'll discuss more of that this morning.
Oh, we will.
Hi, I'm Charles. Again, thank you to Engine and to Drew for that great introduction. I work at the Art Street Institute. The Art Street Institute is a sorry.
Sorry about that.
We're a think tank that advocates for free markets, and I think that the free market position is a good way to start thinking about the whole situation with patents and design patents in particular. We generally think that free market is a pretty good way to get things to happen. That if you allow businesses to compete, they will innovate and they will come up with new things, and that will be good ultimately for everybody. Every once in a while, though, we think that there is a role for the government to play in modifying what goes on in the free market. And in a sense, that's exactly what patents do. Patents are essentially a way of the government saying, we don't think that general competition works here, and we'll provide, certain people with rights against other people, and, therefore will, basically arrange the market in certain ways that we think that the government thinks works out well. And whenever, we see something like that, I think the right question to ask is, well, what is the societal value of that sort of interference? And in the case of patents, the traditional answer to that has always been that by giving inventors rights in something, we're encouraging them, we're providing them with rewards, we're giving them space to do commercialization, that ultimately, by giving them sort of this exception to general competition, they'll ultimately invent more things. And so, in the case of utility patents, I think that story makes a lot of sense. Because we want to encourage people not to just make the widgets that are known, but we want to encourage them to spend a little time investing in thinking about new sorts of inventions that would ultimately benefit us. How does that play out with regard to design patents? Well, design patents don't encourage any new inventions. They don't encourage anything that's useful, right? They're explicitly not useful things. They're to encourage appearances. They're to encourage ornamentation, to make things look pretty. We already have a couple of different types of law that do that. Copyright law does that, trademark law does that to a certain extent. Which, number one, makes design patents seem somewhat duplicative, and what that means is that, to the extent that they are, there's a lot of value in trying to straighten out exactly what the proper roles are of all of these different types of law. And I think the Apple-Samsung case has really revealed that they can get really mixed up sometimes if courts aren't careful. As Matt was saying, we now have design patents entering into the field of software engineering, right? With the user interfaces. Software engineering is traditionally the kind of place where you would use utility patents, where you would say, somebody has invented a new phone, and that's the right way to protect it. And so, I think that the Apple-Samsung case has really revealed that, there's some questions as to what is the appropriate role of this, this fairly old and somewhat strange area of design patents. I think the other thing to look at that's very interesting is what are the industries that this affects. On the one hand, we want to encourage inventors, but on the other hand, if the interference in the market gets too large, we end up starting to interfere with legitimate businesses who are just trying to, get by allowing patent owners to, step in and say, you owe us a whole bunch of money for infringing our patents. There are a lot of new industries that I think are implicated by this. Matt pointed out that the software industry is very interested in design patents. I've been talking with a lot of folks in the 3D printing industry. The 3D printing industry is very, very interesting these days. It's a new opportunity for a lot of manufacturers to do rapid prototyping. It's a very interesting space for consumer innovators who can just create products on the fly, or think I would like to make a modification to my car. I can just print out a modification of my car. Design patents will likely have a lot to do with that. It's come up in the insurance industry of all things, because repair parts, often run into design patent issues. So, I think ultimately what we're finding is that as companies realize that design patents are more powerful than, previously expected, and I think this was largely revealed by the Apple-Samsung dispute, people are looking to, what other industries can design patents play in, and, what effect can they have on that? And I think that that's going to be another really interesting area for us to be looking toward in the future.
So, thank you all, and some excellent remarks from my colleagues. What's funny is when I started thinking about this case in the beginning, and as I was thinking about my remarks for you, a case popped up in my head. I don't know if many of you are familiar with it, and it's Brandier International versus Cascade Pacific Lumber. Any of you ever heard of that case? It's the famous bike rack case. You got it, the tubes. So in the 80s, there was an artist who had basically created the bike rack tubes that everyone now knows today to lock their bikes at. That was actually a sculpture, a piece of art. And it was just placed around for fun, just to look cool and unique and aesthetically pleasing, per se. And when you delve into the case, you'll see all the fact patterns that resulted. What was unique is that the artist did not have the intended or the foresight of realizing that it had a functional play. This was a piece of art, and that was it. People started locking their bikes to it. It started to have a functional play all of a sudden. That utilitarian play all of a sudden showed market value. People would actually lock their bikes. You place this around, this has this tangible benefit, right? And so the artist said, wait, I can make money off this, this is a unique thing. And the attempt for the patent was no longer available because it had been more than a year from public disclosure, right? So the attempt then came to, well, maybe I can still get a copyright, right? And because Cascade Lumber was mass producing this stuff too now and putting it out there. And so the artists and Brandier International and whatnot was like, whoa, hey, this is our intellectual property, our intellectual design. Let's try to get the copyright around this. And the courts looked at it and said, well, the problem is that it has a functional capability now. And so it is no longer eligible for copyright. And that's where it gets really unique, and I think that's what's important what Matt and Charles have been saying, is that you have this confluences of intellectual property rights, which has been given to us since the start of this country, by the way. I mean, the founding of this country included a clause in the Constitution about having an intellectual property system, right? So, James Madison. And so what's really unique is that you now have the situation, over a couple hundred years later, this evolution of thinking over time. And I think it comes to this important thing what Charles is talking about, which is there's the intended and unintended consequences that come from this confluence of law. And so I think what's going to be very interesting going forward is the ramifications, especially around the fact that design patent applications have gone up over the last year, I think over 33,000 for applied, which is a lot. And as a former patent examiner, I can tell you the design patent group at the U.S. Patent and Trademark Office is small. Why? And how do I know that? Because I was in the same building with them. I was in the Materials and Chemical Sciences division, but 2 floors above me was the Design Patent division. It was a very small group. So I know that that number that's gone up all of a sudden has inundated the examiners. Because I remember I was there in 2004 when the backlog was approaching 1 million. I was part of many examiners whittling down that count. And so what it comes down to is not only these policy ramifications that happen, but also the programmatic ramifications. As an ex-patent examiner, I can tell you that we have X amount of time to figure out whether or not a patent application is valid, right? It meets the utility test, the novelty test, and the obviousness test. And when I got to the point of my proficiency, I was given 17 hours per case from start to finish. That's not a lot of time, if you think about it, because that case can draw out to maybe 6 months, no, more like a year, usually from start to finish. And I'm given 17 hours over that year of time to figure out whether or not that case is valid for a patent. And so I think these are important dialogues and conversations to have, not only from a policy perspective, but also from a programmatic operations perspective. If this is truly the way we're going to go forward, the U.S. Patent and Trademark Office needs to be prepared to handle these issues, especially with having the right resources and the capable people having ordinary skill in the art to actually do said work. and making better decisions, because as these decisions go up the chain of command, I don't know if you know, but a decision from the patent examiner goes up to if the applicant doesn't like it, it goes to the Patent Trials Appeal Board, right? If the applicant doesn't like that, it then goes to the Court of Appeals for the Federal Circuit. If they don't like that, then it goes to the Supreme Court. And so that's what's interesting is that also the Supreme Court's been stepping in more lately on intellectual property cases. They haven't historically. This has only been over the past decade, probably. They've stepped in a lot more rigorously than I've ever seen it before. It usually ended at the Court of Appeals for the Federal Circuit. So, interesting times ahead.
There's so many things that I want to talk more about. And I do have notes here where I was going to start, but I just want to add on, I love the bike rack case so much because, and I know we're going to talk more about that, but I just want to say a quick thing. It really kind of gets to the question of incentive, which is what the patent system arguably is about, right? Like, what do we need to do to, as Charles, also, as everyone said, really, like, what do we need to do to incentivize people to create more? And, you know, the bike rack case, she didn't have any incentive, and she created it, and then wanted the incentive, you know, kind of after the fact. So I'm gonna table that for a second, but I kind of want people to keep that in the back of their heads, because I think that's, you know, the question should be, if you actually go back to the constitutional language, like the question should be, how do we get at the progress of useful arts and science? And the question isn't about how do we make certain people or certain companies wealthy, and maybe that is the answer, but that's not the question, right? Okay, so I'm gonna now get back to where I thought we would start, and that's to actually talk about the litigation, to actually talk about the case that went to the Supreme Court, where we are. And Matt, I was hoping you could kind of just dive in there for a second and give us a little bit more overview of
Sure.
how did we get here?
Well, let's see. So, Apple sued Samsung, as everybody knows. So, you know, it was, I mean, to sum up, there was a big dispute about whether Apple claimed, and apparently it's sort of Steve Jobs felt that Android ripped him off. And this started a big feud which has gone on for 10 years, something like that. You know, there were utility patents at issue, which I think that case is still going on. There are cases around the world. I think only the US cases are left. The design patent case involved, at one point, I think 7 patents. Only 3 ended up went to trial. There were, the verdict went for Apple, was appealed to the Federal Circuit. So there was also a trade dress issue. The big thing that we need to worry about here is the damages issue. So under 289, it says that the infringer shall be liable for their total profits. And the Judge Coe decided that the article of manufacture was the entire phone. So Samsung was liable for the entire profits made on the several phones that were at issue, which ended up being, I thought it was $600 million for either way, it doesn't matter. It's a lot of money. I think it's $600 million. That went up to Federal Circuit. There were a bunch of issues appealed. Apple lost in the trade dress issues. The Federal Circuit kind of didn't really address much about the article of manufacture, sort of kind of offhandedly said, yeah, it's just everything. It's the same as the article sold. We know that because it just is. And then Samsung appealed that to the Supreme Court, which said, well, we're reading the statute and we don't see why article of manufacture means anything other than an article that's manufactured, because those words kind of mean what they mean. Scratch, scratch. Now you guys go figure out how you figure out which article that is. Went back to the Federal Circuit, which said, okay, well, we're punting it back to Judge Coe, who then got briefing from all sides. And then Judge Coe said, well, I don't know what I'm going to do, so I'm just going to go with what the government said. And I honestly don't really get her opinion, because she said, well, Samsung's test can't be right because it means that Apple wouldn't get all total profits in this case, so I can't go that way. So, which is a little weird, but anyway, that's how we ended up with this 4-part test, which I personally find kind of incoherent, and I'm not going to repeat it because although it includes the scope of the patent, it also includes a bunch of other things, And we can probably talk about how you end up with different results in different cases for the same patent, which is really not how it's supposed to work, I don't think. That's how we got here. It was a long and winding road, and I summed it up pretty quickly. But
I think that's great. Let me go back to the Supreme Court opinion for a second, because it was written, of course, by Judge Sotomayor, and it was pretty short.
I mean, basically, it was, the words article and manufacture pretty much mean article and an article that is manufactured, so why are you saying it has to be the article that's sold?
So do you think, I've wondered a little bit about this, in the past handful of years, the Supreme Court has not been shy about correcting the Federal Circuit, to put it mildly. But in this case, they didn't go nearly as far as they have been going in kind of beating up the Federal Circuit. Do you guys think there's any, am I reading too far into the tea leaves? What do you think?
So, I think, the relationship on intellectual property issues between the Supreme Court and the Solicitor General is really fascinating. In large part, the Solicitor General has been very, very influential on intellectual property law. Largely, in a lot of cases where the Supreme Court takes grant certiorari, it's because they've asked for the views of the Solicitor General. The Solicitor General has said yes. Many, many times the Solicitor General has recommended a test and the Supreme Court has just adopted it wholesale. But not always. In the recent decision, the Impression Products versus Lexmark case, the Solicitor General proposed a sort of like two-part test, and the Supreme Court pretty much flatly rejected it. There's another example that's not coming to mind. I think it was the copyright case where the Solicitor General proposed a test, and the Supreme Court said that the test just went too far. In the Apple Samsung case, as Matt mentioned, the Solicitor General proposed a specific four-part test for how to determine what the article of manufacture was. The Supreme Court didn't use that, and I think that says something, that they didn't feel comfortable with just adopting what was going on there, and that seems to suggest to me that maybe there are more options out there. Professor Sarah Burstein at Ohio has written a number of really excellent papers looking at the historical interpretation of the term article of manufacture. Her basic view is that the term comes up from earlier patent acts where the types of inventions were distinguished among machines, like natural compositions of matter, so like pharmaceuticals, processes, and articles of manufacture. So articles of manufacture basically were the things that were not the other things, which she basically interprets to mean, based on older case law, anything that is made by man, intended for sale, and not a machine. And specifically, she says intended for sale doesn't mean intended for sale to you and me. It could mean intended for sale to machinists or to folks who assemble things. So, for example, she gives an example of like a glove, where the patent is on just a part of like a design printed on the glove. She says, well, the article of manufacture there is the cloth used to manufacture the glove, because the cloth itself is sold as an article to at least the glove maker. So even though the piece isn't sold to consumers, it still is a thing that's sold. So that at least suggests that there are a couple of alternative tests that are out there. How do you determine among these tests? And if it goes back to what Julie was talking about at the beginning, what are we trying to do here? Ultimately, what we're trying to do is encourage innovation. And the problem is that, given the state of the law right now, where you have this rule that, somebody gets total profits on whatever is the article of manufacture as defined, the risk is that you could be giving total profits on a very, very large thing for a very, very small component. The classic example of, a cup holder in a car. If, there's a design patent on the cup holder, then, you get total profit from the car. And so there have been a lot of efforts to look to ways to limit that definition. I think the solicitor tests that are out there. How do you determine among these tests? And I think it goes back to what Julie was talking about at the beginning. What are we trying to do here? Ultimately, what we're trying to do is encourage innovation. And The problem is that, given the state of the law right now, where you have this rule that, somebody gets total profits on whatever is the article of manufacture as defined, the risk is that you could be giving total profits on a very, very large thing for a very, very small component. The classic example is, a cup holder in a car. If, there's a design patent on the cup holder, then, do you get total profits in the car? And so there have been a lot of efforts to look to ways to limit that definition. I think the Solicitor General's test was something of an attempt to do that, and there are a number of other tests, like I said, the one that Professor Burstein has proposed and others. And ultimately, I think the way to evaluate them is which of these gets to incentivizing innovation the best. Which of them makes sure that the reward is commensurate with the invention. And I think that that's how, hopefully, courts will continue to look at this problem.
I think part of it is all really kicked off, I think, in my opinion, with the Supreme Court stepping in a lot more after KSR versus Teleflex. If anyone's familiar with that case, and that was the one with if I recall, the braking in the car and stuff of that nature, or brake pad. It's been a long time. That is where I all of a sudden, because I was at the patent office when that was going down, and we saw that kick off, and this explosion of interest, I think, in my opinion. And
Explosion of interest in what?
in rectifying intellectual property law and case law in general. It was, there was for a while, the Court of Appeals for the Federal Circuit is basically where it stopped. Rarely would it go up above that, but because KSR Teleflex started to challenge the metes and bounds of the obviousness, the challenging of the USC 103A means for patentability, that started to come into this question of what is obvious, what is not, and it started to, I think, get more interest all of a sudden of what are these metes and bounds when it comes to claim language and what their intended protection should be. And the heart of a patent, in general, in particular patent law, is the claim. I remember when the PBJ Smucker case went down like that. I just joined the patent office when that case was finished, and the patent commissioner had rescinded the claims for that patent. And we got vilified at the U.S. Patent and Trademark Office for, you gave the Uncrustable sandwich a patent. And we laughed about it, and we're like, crap. But then we what's funny is I would show the patent to folks and say, read the claims. And when they read the claims, they're like, that's not what I would have thought. And I go, I know, that's, I think, why the examiner probably initially allowed it. And I think it comes back down to is this, the patent examiners are put into this silo when they make these decisions. And we look at all the literature around us, but with this pressure of time and quality and everything else hammered on us, you get the best product you can get. I think in addition to KSR Teleflex, around that same time also was when Apple and Creative were getting into their, I don't know if you guys remember Creative Technology. They were the ones who created the competing MP3 product to the Apple iPod. And Apple had been infringing their intellectual property. And so there was a question around that intellectual property portfolio that Creative Technology had, and then Apple basically bought it out. They said, here, just take this money and walk away. And they walked away. And if I recall, didn't even Research in Motion and Apple have a litigation around that same time? Because there was if I recall, that was also around that same. And the reason why I remember that is because the examiners at the office were all of a sudden called in to basically do what's called a re-examination. Take a look at these patents and re-examine it for whether or not it really was pertaining to the right metes and bounds. And I think it was just during that time period of 2002, 2004 to present is this, a lot of different confluences have happened, and it's gotten the courts, coming up with different opinions, and the Supreme Court seeing what the Eastern District is doing, what CAFC is doing, and saying, okay, maybe we need to step in and rectify. That's my speculative opinion, but I also knew members from the CAFC, the Court of Appeals for Federal Circuit. I was friends with two of them who were actually alumni of my alma mater, and so they kind of hinted to me at one time, it's like, yeah, they're stepping in because they don't like the decisions we're making. And it started to become contentious at times between the two.
So they know what's going on.
Oh, yeah.
What about, so I think that's really helpful, and I think, we've seen a lot of that happen in a lot of these other trends that we'll dive in a little bit more, of course, as technology has become so much more widespread. The way patents and other intellectual property rights interact with technology, is kind of front of mind. But I'd like to actually take a step back and think a little bit more historically for a second. Charles, you started when you talked about some of the great work Sarah's done around article manufacture, but I was hoping we could just talk a little bit about actually the history of design patents. Like what, at its most basic, like what are we trying to get at with design patents that's different fundamentally from utility patents? Like why can't we just do it all in one thing?
Yeah, that's the historical perspective is a fascinating situation. So let's go back to English patents in the 1500s.
You guys didn't know what you were getting into.
I have a very narrow knowledge of like certain things. So English patents in the 1500s were basically just the queen, it was Queen Elizabeth I at the time. Somebody would come to her and say, hey, I got this cool thing, I want to start a business on it, and can you keep anybody else from getting in my way? And she'd said, sure, here is a patent. A patent meant literally an open letter that gave, and these were often used to basically give people monopoly privileges on like fishing in a certain river, or making certain types of leather. They didn't necessarily have anything to do with inventions. The point is that they were just government grants of privilege, which were intended to affect the way that the market worked. These ultimately get cabined into the invention patents that we understand today. But there were a couple of interesting features, I think, that play into design patents. The first is that they only covered whole inventions. The idea that you get a patent on an improvement was considered what they would say adding a new button to an old coat. That's nothing new. That's nothing worth granting a patent on. So patents were not granted on improvements or small changes to inventions. So design patents, I think, they arise kind of in the late 1800s, kind of as a result of a gap in the law. We didn't have any good trademark law at that time. There was no federal trademark law. Copyright law was largely inapplicable to, artistic works that were applied to useful things. And so there was just this kind of gap of like, well, how do we protect, pretty designs on toasters or trains or something like that. And so they came up with design patents as a way to do that. The key though was that we still had this tradition that patents were for whole things. And design patents were ultimately meant just to cover, entire products and the design of them. As the guest mentions, that changed over time, and we left our focus from the nature of the invention as kind of the defining characteristic of what was patented, and moved to the claims, the dictates of the inventor in the specification given to the patent office, where the inventor says, I think that these are the key features of my invention, and so, if somebody infringes these, it doesn't have to look like my original product. It can be anything that you want, as long as it contains, these three features. And I think that that's been, really the most significant change with regard to design patents. Patents overall, but specifically with regard to design patents. And it explains why we have this really weird provision that says you get the total profits on the product. Because at the time that came into place, design patents were for entire products. And it made sense to say, okay, so if somebody has taken the design of your entire product, then you get the profits on the entire product. It's been this discrepancy in the law where the nature of what can be protected has changed. You can now have a design patent on only a small piece of a product rather than the whole thing. But the damages clause still is based on that older notion that design patents are meant to be on whole products. And I think it's led to this discrepancy that's ultimately caused all of this weirdness about why do we have this statute that gives total profits on potentially only small parts of things. So I think that what's the right way for that, right? Well, the obvious one is to, fix it by legislation. Well, if we've changed one part of the law, we should change the other part of the law. That's probably going to be fairly difficult. So ultimately, what we fall into is, trying to use, various legal maneuvers within the courts to, look to older definitions of terms as a way of sort of alleviating this discrepancy.
So there are two we're in a little bit of a fork in the road. There are two things I want to make sure we have time to cover. One is the actual proposed test and like where we actually think it should go, where the panelists think we should end up as a practical matter, as a legal practical matter, I guess I would say. But the other side, and I think I'm going to go with the other fork, I'm going to choose the other road first, is what does all of this mean for people who are actually trying to build things? What does this mean for patent examiners? What does this mean for attorneys? What does this mean for the people who, right now, there's a lot of uncertainty in the kind of legal framework around damages. And actually, I'm going to take this one to you first. But number one, what is this? Well, let me ask you a couple parts. What does the current uncertainty mean? But also, if you want to go into this too, what did the old version of the law mean? And something I'm interested in, I'm just going to throw it out for everyone too, is have we seen a lot of abuses in the design patent space? We obviously see a lot of trolling, for instance, for sure, across the patent. And what does that look like?
Basically, it's going to be looking at trying to reconcile this with all the other case law that they would use in the manual for patent examination procedure. And so I think there's going to be a little bit of, well, clarity's sake of saying, well, this is what we do for now based on what precedent is, and if things change, then we have to just change protocol thereafter. I think it's because of the uncertainties around this, it is going to create probably a de-incentivization for some folks to do what it is they do, and in fact maybe not want to participate in the space of innovating because of the fact that they fear that they may be infringing on something that they don't know is out there and don't understand. I think another thing that's actually important is the fact that you've got this interpretation of the law as it relates to mobile devices, but how does it interpret when it comes to fashion or automotive, and with the Internet of Things coming on more and more, that kind of stuff. It's testing these new boundaries in areas that we just are not sure is applicable or not. I got to think about that a little bit more, but I think that's where I'll start off with.
Do either of you guys want to weigh in on that?
Well, yeah, so it's actually interesting the way that, just talking about abuse. So, I mentioned graphical user interfaces. I think it's a little early. Apple arguably is pushing the line the way that they're trying to claim graphical user interfaces. An interesting area of abuse is something that Charles hinted at. Some auto manufacturers have been getting design patents on auto parts in order to make it difficult for manufacturers, third parties, to manufacture aftermarket parts so that they can essentially corner the market and make it impossible for people to get aftermarket parts using design patents, which is, it would be impermissible under antitrust law to block aftermarket sales, but if they use design patents, they may be able to do it. So it's an interesting use. It's kind of flown under the radar. But, and I don't know if they've actually gone about enforcing them, but they're definitely, they've been getting design patents. I don't know if they've started using them, but that seems to be the indication. That would be an explanation for why they're getting them. So it's, we'll see. Again, user interfaces are kind of interesting, especially so that the user interface at issue here is just a disembodied screen. Well, that screen could be on a phone, as in this case, but it could be on a car, could be on a refrigerator, could be on a lot of things. That's problematic, especially when you have a rule like Judge Koh used, where, well, you have to look at the product and how, so you could end up with, well, maybe in the phone case, you get the profits on the phone, but in the car case, you don't, because the car has a lot more to it than the screen, so you end up with a different profit value, even though it's literally the exact same screen. That's an odd result in patent law when you literally have the same physical component. mean, that's something to think about, that we have a test now where you literally could have the same component physically put in different devices, and you end up with different damages because of what they were put in. And it's just something to think about, that, this kind of a test could be problematic. And that, I think, as Nagesh was saying, could make some small companies start to think twice. It's bad enough you have to think about patent trolls and utility infringement. Now you're gonna think about a big company coming after me with some design patent, especially Apple. Are they gonna come after me with some patent on a half-inch block of something, some little piece of some component, and claim that I infringe that, and then, get lost profit, my profits on the whole thing? I don't know.
One other thing I wanted to say earlier, and I had forgotten it, was the whole point of intellectual property rights, especially patents and copyrights and whatnot, was to get people to disclose their invention, right? They get a limited term monopoly in return for disclosing their invention for the promotion of the useful arts and sciences. When you start to deter people from, those kind of incentivizations to disclose, they start to keep it secret, and then they start to operate in trade secret format, and you start to have a dilution of the information going out there. And so that's, it's this balance back and forth. Do we want this information out there so that everyone can build off on it and be able to do more with it? And if so, how do we prevent the abuses that can result from taking advantage of that benefit?
Of course, so with design patents, they have to be publicly sold. So the question there is.
I think that's so important, and I know I'm the moderator, but I'm going to weigh in for just a second because I can't help myself. And I also want to make sure that we save some time to talk about the test before we open it up for questions. But I just have to say, one of the bees in my bonnet and things I think have really fallen apart, and the patent system more generally, is that the notice function really isn't working like it's intended. And I think some of it has to do with actual companies who are trying to hide things, but I think some of it just has to do with confusion and the inability to do. If you're a small innovator and you can't afford a really, a lot of legal fees at the outset, searching through patent office records, trying to understand, trying to get opinion letters, those things are really, really hard. And then if you add this kind of additional element that Matt was just talking about, which is to say, so this patent, maybe you can find the patent, but also it could mean a bunch of different things at the back end. If you do get in trouble, you cannot properly assess your risk as an innovator. And that's a really dangerous place. And I think that's terrible.
Yeah, there are a number of fascinating studies by Professor Lisa Ouellette, in which she surveyed various technologists and said, do you ever use patents? Do you ever read them? And a lot of them said, for technical purposes, to learn things, right? And so the finding was, yeah, we'd love to, but we can't understand them. They don't make any sense. So it's a little unfortunate. A large part of the patent system was to develop that sort of technical library of information so that people would disclose new inventions. So in terms of the sort of question about impact that we were talking about before, I'll just say something fairly quickly. Everyone wants to know about design patent trolls. Are there going to be design patent trolls? And I think the answer is not yet, but maybe. What we're seeing right now is a great deal more aggression in the types of patents that are being obtained. If you imagine a company who is just trying to get a defensive patent to make sure that people aren't stealing their product, they would basically get a patent on the whole design, right? The corners here and the cutout here, this little notch here, everything. If what you care about is making sure people don't rip your product off, that's what you go for. What we're seeing now is a lot of companies who are saying, well, we don't really care if somebody takes the whole design. All we care about is this little oval right here, right, just in the top corner. There, Professor Burstein, she has a blog of these sorts of patents, and one of them is basically just on the little aperture for the camera on phones. It's a design patent just on that little cutout. It doesn't say it has to be on any particular shape of a case or anything like that. So, those patents are right now, I think, being applied for by companies who are making the products, right? And, generally we don't think of trolling as a practice done by operating companies. But what happens when those companies go out of business, or they decide that they need a little cash infusion, or any number of things, and they sell those patents off, right, to folks who aren't manufacturing, who don't have the same incentives to play nicely in the marketplace? That's basically what we saw with the software industry, some years ago, which is what led to all of the litigation. So, I don't think we're seeing the type of abusive litigation over design patents that we've observed with regard to software patents yet, but we are seeing the base being built. And it remains a question of whether or not changes to the law make that base useful for abusive practices, and whether or not they arise as a result. But I certainly see that the field is the table is being set in a sense.
That's perfect segue into the changes in the law. But first, I have to say that Charles talked a couple times about Professor Burstein, and if you guys care about design patents and aren't already following her, I highly recommend you do. Even just her Twitter feed, she's constantly tweeting design patents. It's great. It's actually really fun. She's awesome.
A lot of spoons.
Yeah.
A lot of cups.
And it's just also interesting too. It's interesting. Okay, so the test. I'm gonna rattle, just kind of set the framework. I'm gonna rattle through these at a very high level. This is the Solicitor General test that Judge Koh has said she's using. 4 factors: the scope of design in the patent, the relative prominence of the design within the product, whether the design is conceptually distinct from the product, and the physical relationship between the patented design and the rest of the product. Highest level, I'll talk through that quickly, but I kind of want to throw that out there. We've talked a lot around this, but I would love to kind of hear your thought, and I'm open to anyone opening this up. Do you think this is a good test? I think we've already talked a little bit about that. If you don't think this is a good test, what would be a better test? And do you have any other kind of predictions for how this all could end up?
I think it's subjective, just based on the fact that it's going to be left to the person having ordinary skill in the art, the examiner, to determine, the comparison of A to B, B to C. So I think it was probably intentionally left that way, to leave it at that, leave it at the examiner's discretion a little bit, from a patent office. Well, I am not speaking on behalf of the patent office, but from what I predict, that would be the case. As I remember when we looked at the test for Graham v. Deere, when we do a 103 rejection analysis. So that's what I'm interpreting that to be. Do I think it's a good test? I think it's as good as it can be at the moment.
So I think that there are kind of 2 questions that sit along with the test that aren't necessarily in the words of the test, and they are, whose job is it to prove one way or another how that test works out? What's the burden of proof?
Right.
Is the accused infringer's job, or is that the patent owner's job? And second, who's going to make the final decision? Is it going to be a jury, or is it going to be a judge? And these are both very important questions, both because they help you figure out what you're supposed to do, but they also define the responsibilities of the patent office, of accused infringers. They determine what the costs of litigation are going to be, whether these issues can be decided, early on in the case at a summary judgment stage, or if you have to go all the way to trial before you can decide these sorts of things. I think these are important aspects of the test that need to be kind of considered alongside with the substance. The government's test largely says the burden of proof is on the accused infringer, and that ultimately this has to go to the jury. That this is subjective. It has to be decided by fact finders. I think that these are slightly concerning results because number one, it increases the costs of trial, and number 2, it puts the burden on a side that wasn't necessarily present at the time that the patent was being prosecuted and wasn't present at the office. And it leaves real questions about how the office is going to decide, what's the relevant article of manufacture to the extent that they're deciding what sort of patents they should be granting and how to make sure those patents are correctly crafted. If I had to make a prediction, the Federal Circuit sure likes saying that they do everything, and I would be fairly surprised if they just defer to the jury. Now, that being said, the one place that I've seen them defer to the jury is in the other Apple-Samsung cases, With regard to the utility patents, that was, one of the decisions where the Federal Circuit said, well, we think that the jury made a decision on obviousness, and we are going to say that that was a matter of fact, so, the jury verdict stands. So, interesting question whether or not that's going to kind of hold over in this situation. But generally, the trend has been that the Federal Circuit likes to say that things are matters of law, that they're within the court's expertise, and that they can decide those sorts of things. So that would be kind of where I imagine things going.
Yeah, so I think I've tipped my hand when I say that I don't really like the test. I may have hinted at that a couple times. And the reason I don't like the test is it's so subjective, and it only, it's a 4-part test, and only one of the parts actually refers to the patent itself. And it's a design patent. And normally in patent law, we look at the patent. That's the whole point, right? As Giles Rich said, the claim, the name of the game is the claim, right? It's the claim that's supposed to tell us what we're talking about. And yet, most of the test has nothing to do with the claim, which is the design patent itself. There's only one claim in a design patent, which are the drawings. So it seems to me that the proper test is to look at the smallest, in a multi-component product, the smallest component that contains the claim design. And if that turns out to be something that's not particularly profitable, well, then that means that you got too cute in your claiming and tough luck, right? I mean, the problem really is that we have companies like Apple that whine that, well, we only claim this little thing, but we really want that $600 million, so you have to find a way to give us our money, right? I mean, that was, if you listen to the Supreme Court argument, really, their argument was, we really want our $600 million. That was their argument. That was their whole argument, was we really want our money. And their main argument to Judge Coe was, we really want our money. You should give us our money. That was it. Why should you win? Because we really want that money. That's why. And, that's not legal reasoning. The fact that they don't get as much money is not a reason to have a legal test. If they wanted to claim the phone, they should have claimed the entire shape of the phone. That's not the law's problem. It's not society's problem. That's Apple's problem. If Apple wanted damages for the whole phone, they should have gotten a design patent for the shape of the whole phone, right? That's the point. If they want to claim little parts of it, then they don't get the whole phone. That seems like common sense. But, so a test, what's happening here is that somebody's trying to come up with a test that lets Apple claim a lot less than the whole phone, but still get damages for the whole phone. Because gosh, their commercials are so cool, and they do this awesome stuff, and they have the shadows dancing with the headphones, and I really want to give them their money. That's not the way we do patents, I think, right? The patent is supposed to tell us what it is. As far as predictions go, honestly, the Federal Circuit really loves those shadows with the headphones on it, so I predict the Federal Circuit will probably modify the test slightly, but still find a way to give Apple their money. And it will probably go back to the Supreme Court, which will say, how did you find all these other factors that are nowhere to be found anywhere in the law? And it will, I don't know, maybe we'll come up with something that has something to do with patents again. I really hope.
I should ask predictions what year we'd be done. I'm going to ask
Good
you
luck.
guys to, if you have one, let us know about your favorite design patent. But I also am going to open it up for questions. We've got...
I hate them all. I don't really. I don't have a favorite.
You don't have a favorite design patent, Charles and August. Do either of you have a favorite design patent?
Well, I told you about the phone one. That was pretty
Yeah.
funny.
I don't think I have one at the
All right,
moment.
that's fine, no pressure. Okay, let's open it up. We've got time for some questions. Anyone? Yes?
Hi, Chris Morris, Operator Commissioner, Industry Association. A couple, I think, that's on two different topics. First is that we had we now have a new director of the PTO. And one of our longstanding concerns is patent quality, particularly in the software arena. My question would be is, based on your knowledge of the design space, is there a need for that same type of initiative in the design patent area? Because when you talk about, basically what's the people in the door. that's the kind of thing that might make our members a little bit nervous, especially as applied to GUIs. And the second question I have, which is totally different, is in the, in the cheerleading case, the
Varsity Browns case, yeah.
Right, the Supreme Court found a level of protection in utilitarian designs that I think surprised some of us who follow the copyright law fairly closely. And I was wondering if you thought that that was going to have, that decision or that kind of analysis is going to have any effect on the way they might analyze obviousness in the design context later. Those are two totally different questions.
Yeah, so on the first one, I think you'll know this a lot better than I will. The Patent Office has they sort of had this open proceeding as to design patent quality. It came out of this sort of weird hypothetical that somebody at the Patent Office came up with. The theory was, if you took, if you got a design patent on like a piece of graph paper, just a grid, and then, progressively filed patent applications blacking out some of the elements of the grid, you can get a design patent on literally anything you wanted, which, is clearly not supposed to be possible. But I think that, starting from that, there's been a degree of recognition that, something is going on with regard to the with regard to the claiming schemes and with regard to the quality of the design patents. I think that there's some interest in looking at it. I don't know whether, with regard to soon-to-be director Yanku, whether or not that's going to be at the top of his agenda. I mean, IPR is kind of a big thing right now, yeah. But it is out there, and I think that there at least has been some discussion in the past. On the Varsity Brands case, I agree. It was somewhat surprising where the Supreme Court went with that. I think for practitioners, it's not going to make too much of a difference. The view of practitioners is generally going to protect everything as many ways as you can, right? So, we're not going to stop with copyrights. I think they've been trying to use copyrights for a long time, but they've also got the design patents, and they also have the trademarks, and they also have trade dress. I think they'll go for everything. My guess is that because of the fact that patent cases go to a different court than all of the other types of cases, the inclination will not be to view copyright as having much of an impact on what design patent looks like, even though I think you're right, it probably should. And that is just sort of an odd quirk of the jurisdictional system that we have.
Do we have any other questions? Right here in front.
Does it bother you at all that design patents don't get issued, they're never published or disclosed to the public?
Not really.
So I guess in the part you issue a bad design patent gets issued, and the public has no disclosure of the ones that never got issued because they were also just as bad, to then invalidate.
But what's a bad design patent?
One that was extremely basic out there.
So the question is, if somebody else filed an application
Yeah,
first
right,
with the same line.
And that would have been part of it.
Yeah, but there's no, but we're stipulating it's a design patent, so there's no innovation here, right? It's just a design. So it's ugly?
Well, never was issued.
So,
But some other prior art that you can't use to then invalidate the one that did get
so
issued.
pretty much
Okay,
all
but so
of them.
the art is still out there, though.
Right, and I think,
How?
But it was invalidated, right? So it didn't get issued.
Maybe the internal office only saw it, right?
Right.
you're looking at
But
it from the perspective if basically anyone else wants to file design patents in general or whatnot, they're put on notice that, hey, this application was denied, so if I try to submit something stupid like this, it won't. Yeah, I mean, I could see that argument.
yeah,
I just think because it's not as, the applications are just not as high as like in the other space like utility and whatnot.
and honestly, correct me if I'm wrong, but not that many applications are denied.
Yeah,
It's really hard to search design patent applications,
yes.
and
They're under classification. I mean, the classes are pretty basic that you can go through it very quickly.
yeah, but the approval rate is pretty high.
I mean, while we're on the topic,
I think he's talking about the subjectiveness of invalidating. It's pretty difficult in general.
We had another question.
Yeah,
Hi, Matt. It's
Hey, Beth.
Brown, East Oregon Penny Center.
I vaguely remember you.
Do you take issue with all patent design patents that are directed to replacement parts or just ones directed to automobile?
Oh, me personally?
I'm just curious, because, yeah.
Well, no, so,
Because I actually, so first of all, I think some of the things you said are inaccurate, that a lot of the car companies actually license their design patents for the
Yeah.
automobile parts to O&Ms. And part of that is a quality control, so that when people get a part that looks like their Toyota Camry, they know that it actually has the safety benefits as well. And I know that.
wait a
that
minute,
you
safety
are-
benefits, then those shouldn't be design
No,
patents,
they're
that's
not part of the
functional.
design patent. My point is that a company has a collection of rights associated with.
Oh, if they're licensing it, then it's
They
fine.
license all of those rights to O&M companies who make bumpers.
Well, then that's
that
fine.
look like, but you said it was antitrust to enforce your design.
Oh, it's only if they're doing that, which I think I said I didn't know if they
No,
weren't.
they actually are, and then Ford filed a lawsuit, 6 or 8 months ago against a company that was making knockoff headlights that they said were not of the quality that Ford wanted.
Were they using
Part of-
design patents?
Along with other rights, because they bundle the rights to protect the parts as a group. I guess I.
Well, the utility patents, obviously, that's a different issue, right? Because that is a safety
The
thing.
design patent is the signal to the consumer of what the product looks like. My grandmother doesn't know, she sees a Ford.
Well, the trade dress is what the product
No,
looks
you
like.
can't get trade dress unless you have secondary meaning.
Right.
And trade dress takes time to develop a secondary meaning. My point is that the design patents are not, I don't see that as an abusive thing. I agree that it perhaps isn't part of the original constitutional reason for design patents, but I think we've found that some things are actually beneficial beyond the original constitutional.
Well, but if the utility patents are sufficient, then that would seem to me to be
But
the point.
They aren't, because
You just said they were, 'cause they're not-
On the.
You just said they were using the utility patents.
They're using the utility and the design together. It's a package of rights to protect a single product.
So I think you guys are agreeing that there is a use case where this makes sense, and there might be a use
Yeah.
case where it doesn't make sense, and
No, Matt, you're thinking about it being abusive.
I will concede that I was being overbroad, sure.
I feel like that's a bit, yeah, that's an overstatement.
Okay.
do we have any other
You win.
questions? Right here.
Well, actually, the query on the new director for the U.S. Patent and Trademark Office, because I know he was just confirmed yesterday with Senate. I think it'll be interesting to see so that office has been shaped significantly, I think, over the last 15 years. I think, post John Dudas, and really it was John Dahl who was running the brain power there at the U.S. Patent. He's a friend, so I'm just saying I know Dahl very well. He's been a mentor of mine. He did an excellent job. I think he got hit a lot with some negative stuff that was unfair, but I think he meant to do the right things, and actually what Dahl was trying to do to help ensure patent quality, ensure timeliness of those patent applications to be reviewed, and to ensure it was done efficiently is not easy. And when you're dealing with a backlog of 1 million patents that they were facing back in 2004, it's going to be tough. I think on top of that, what Dahl was trying to do forward, actually, Dave Kapos got it done. I mean, if you think about the AIA, a lot of the stuff that went into the American Invents Act was stuff that Dahl had proposed, and John Dudas and John Dahl were stopped a bit, and then Kapos figured it out right with the team, and got it legislatively done, because the PTO doesn't have that rulemaking authority that other agencies do, and so Kapos got that done, and Undersecretary Lee stepped in, and quality's always been a critical issue. I think it's just very difficult, and I remember Bob Budens, who was the Patent Office Professional Association rep. I remember when he testified on the Hill like 15 years ago. He said, "Time, quality, money. Pick two," and that was it. And I think you can have all three. It's just you got to be willing to be patient. But
So I
Wait,
think we've
then
got
you're
time for
giving
one
up
more.
time.
what was it?
And you're giving up time.
Well, not always. If you automate.
One day. That's the next panel, is on automating the PTO. We got a question in the back.
Okay, so over the years, we've seen all sorts of caps on damages. I was sitting here trying to think of a good case. BMW versus Gore, I know, was a punitive damages case, but the courts came out and said, you can't award these wild damages. And in the patent world, we've seen a portion of the damages. Why is it not applicable to either the general principles of damages, or more specifically, the kind of portion of receiving rate of patent, utility patent side, to this group of cases? I just don't understand why the hesitancy.
Or reasonable
So
royalties.
I made that argument at the Supreme Court. I pointed out that they have constitutional due process limits on what sort of damage you can you can propose. The difficulty is here we have a statute that says the opposite, right? We have a it's in 35 USC. What is it 282? Where it says you are not supposed to issue the apportioned damage. You are supposed to issue the total profit.
What about reasonable royalties?
Yeah, well,
You could be entitled to reasonable
yeah.
royalties as
So
well.
you can get kind of whichever.
Yeah,
one
289
you
is not
want.
exclusive.
Yeah, so
Would be
I
better,
think if we ever get to a situation where the damages really, really don't look proportional, yeah, I think there's a constitutional problem there.
All right.
I think that, I'm sorry, Julie,
no,
I think
go.
that I interrupted that gentleman from asking his question, so.
I had one
Oh, yeah, go ahead.
Yeah, my name is Dan Scher, I'm a patent attorney, and I'm very pro-patent. And those
Okay.
things are not mutually exclusive. And this is, thanks for the panel. This is the most stimulation I've had before lunch so far in 2018.
Oh my God.
You know, I've heard a lot of great discussion. We talk about and I think everyone seems to understand the patent system, design patents, it has to evolve with our economy, with our society, and it's very hard to keep up. People straight up rip them off, copy their products, real rips, and import them. And we've been able to use design patents to shut them down before it was able to totally destroy their business. And a lot of the discussion we had today really, in my mind, had to do with a lot of the fringes, like Apple and Samsung settling a beef in the design patent area, or the idea that there's kind of design patent trolls out there that I haven't really heard too much about. But the things I wanted to really say is that the central purpose of design patent was preventing straight up ripoffs. And we haven't talked about that today. And I think that as we go down all these other fringes, we have to make sure, and it's more of a comment than a question, we have to make sure that we protect this main function, which is very important for our economy, and especially small businesses.
I think that's,
It's a very fair point.
It's a very well taken point. And I would say one of the, and this is true in utility patents, this is true with design patents. I think something that's really interesting about this moment in time that I find intellectually fascinating and really interesting is that as technology has been evolving so rapidly, we've kind of talked a lot about that today. It's been one of the themes. And as how we use technology has changed, and there's so many more patents that cover any given smartphone. This is the stat everyone always uses. Than kind of traditional inventions. The patent system also is evolving and changing, and really trying to find those new balances are, we're in an interesting time in the law, we're in an interesting time for a lot of things, but an interesting time in the law on this stuff, and hopefully we'll get it as close to right as we can with as few losers and as many winners. And on that optimistic note, thank you all so much for coming. We really appreciate it. Thank you.